Hey, welcome to Legal Lessons. My name is Tari, and today's video is all about Beyonce's fights for Blue Ivy's rights. In 2012, Beyonce gave birth to her and Jay-Z's first daughter, Blue Ivy Carter. And in 2016, Beyonce applied with the United States Patent and Trademark Office to try to secure her daughter's name, Blue Ivy Carter, as a trademark. Now, she applied to trademark this name in a lot of different classes. And when I say a lot of different classes, I mean literally almost everything you could ever think to sell. Now, some people speculated that Beyonce did this for the purpose of preventing other people from registering her daughter's name and capitalizing off of the name that was really popular at the time that she was born. Now, the issue is that a woman by the name of Veronica Morales had already had a trademark register under the name Blue Ivy. She had been using the name Blue Ivy for her company, Blue Ivy Events Planning. Now, Ms. Morales claimed that she was using this name years before Blue Ivy Carter was ever born, back in 2009. Well, Ms. Morales was able to successfully register her trademark back in October of 2012, and so she beat Beyonce to the punch. So when Beyonce submitted her application in 2016, Ms. Morales did what any reasonable, prudent, vigilant trademark owner should do, and that is she opposed the trademark application. Now, if you don't know why she did that, go ahead and check out my last video, which I'm going to link right here for you to learn why you need to enforce your trademark rights. Long story short, Ms. Morales went ahead and filed an opposition to Beyonce's registration, and needless to say, the fight ensued. Now, this battle went on for years, starting in 2017 and not concluding until 2020 when the Trademark Trial and Appeal Board, who's obviously a part of the Beehive, sided with Beyonce and agreed that her trademark application could go forward and be registered. One of the legal bases that Ms. Morales tried to challenge Beyonce's application under is our legal lesson for today. Ms. Morales tried to defeat Beyonce's application by claiming the likelihood of confusion. The Trademark Act basically prohibits the registration of a trademark if it is too confusingly similar to a mark that's already registered or a mark that someone in the United States is already using. So Ms. Morales basically said that Beyonce's mark should not be registered because my mark is Blue Ivy, her mark is Blue Ivy Carter, and that is confusingly similar. The purpose of this is all about distinguishing the origins of the goods and services. Now, imagine if we had two brands with the exact same product and the exact same name. How are we supposed to distinguish the brand that has the trash quality from the brand that has the great quality? This is why it's important to make sure that trademarks are not registered that are too confusingly similar to yours. We do not want people confusing which brand is the source of which product. Now, at one point during this legal battle, Beyonce's legal team said that Ms. Morales' claim that her trademark was confusingly similar to theirs was absolutely ridiculous. They said that Blue Ivy Carter is the child of two internationally known superstars, and Blue Ivy Events is owned by someone that you just heard about in this YouTube video for the first time ever. Well, the Trademark Trial and Appeal Board agreed with Beyonce's team and ruled that the marks were not too confusingly similar because they were different goods and services and that they had different channels of trade. So essentially, Beyonce was allowed to go forward with her registration and register her daughter's name on the principal register, which is Blue Ivy Carter. A little earlier, I mentioned how some people thought that Beyonce was registering the trademark in order to prevent others from using it and not actually to start a brand of her own. And this was actually one of the reasons that Ms. Morales was attacking Beyonce's application. She said that Beyonce essentially committed fraud by claiming that she was registering this to use it and use his mark for a business, but in reality, she was only trying to stop others. Now, to prove this, Ms. Morales even cited to an interview that Jay-Z did where he said, quote, "People want to make products based on your children's names, and you don't want anyone trying to benefit off of your baby's name. It wasn't for us to do anything with. As you can see, we haven't done anything with it." This was really damaging to Beyonce's application because she was claiming that she was registering this with a bona fide intent to use it, but her husband was in a media interview saying that we actually don't want to use this, we just want to stop others. Even considering a statement from Jay-Z, the Trademark Trial and Appeal Board, who's obviously in the Beehive, still agreed to allow Beyonce's registration to go through. Should Jay-Z and Beyonce be allowed to register their daughter's name as a trademark and prohibit other people from using it? Do you think they'll genuinely ever actually start to use this name in business ventures and to actually put it out there and use that mark? Don't forget to like, comment, subscribe, and click that notification bell so that you are notified the next time I post a video. Until next time, stay safe and out of trouble.